Good afternoon. My name is Ben Barrows. I'm Dean of the College of Law. I'm delighted to welcome you to today's Stranahan National Issues Forum lecture. This series began in 1990, supported by an endowment from the Stranahan family. The forum is a joint program between the University of Toledo College of Law and the college's Federalist Society, with the purpose of addressing issues of national importance through the lens of the American legal system. Over 40 of the nation's leading legal academics, economists, historians, political scientists, judges, and public policy professionals have participated in the Stranahan National Issues Forum. To introduce today's speaker, it's my pleasure to turn to Lee J. Strang, the John W. Stepler Professor of Law and Values at the College of Law. Professor Strang came to the College of Law in 2008 after teaching at two other law schools. He's an accomplished teacher and scholar. Among his many other duties, he's the faculty advisor to the College of Law Federalist Society chapter and coordinator of this lecture series. Professor Strang.
Thank you, Dean Barrows. Today's Stranahan Lecture, like the Stranahan Lecture Series more generally, provides a critical contribution, a valuable viewpoint to our university's debate and discussion on important national issues. It's therefore my distinct pleasure to introduce our Stranahan lecturer, Professor Stephen E. Sachs. Professor Sachs, the inaugural Antonin Scalia Professor of Law at Harvard Law School, is a graduate of Harvard College and Yale Law School, and was a Rhodes Scholar at Oxford University. After law school, Professor Sachs clerked for Judge Stephen Williams on the United States Court of Appeals for the District of Columbia Circuit, and then for Chief Justice John Roberts on the United States Supreme Court. After practice at Mayer Brown, Professor Sachs taught at Duke University School of Law for about a decade, prior to joining the Harvard Law faculty in 2021. A member of the American Law Institute, Professor Sachs is a prolific scholar, authoring and co-authoring scholarship on legal theory, the jurisdiction of state and federal courts, the history of procedure in private law, and the topic of today's lecture, constitutional interpretation. In his Stranahan lecture today, Professor Sachs will address how American lawyers and citizens should approach the Constitution and its authors. His lecture will discuss how we should understand the founders' historical legacy and how the Constitution they wrote might remain binding today in law and also in conscience. Professor Sachs will speak for approximately 40 minutes, leaving 15 minutes for your questions and comments. Please join me in welcoming Professor Sachs.
Thank you very much, making sure that the microphone is active. Thank you very much to Professor Strang, for the Dean, to the funders and organizers of the Stranahan Lecture, and to all of you for coming to hear it. My talk today is on originalism and original sins. Originalism as a legal doctrine is in a strange place at the moment. It seems to go from strength to strength in the courts, but to face a very deep vulnerability in the country. On the one hand, more judges and justices than at any other time in recent memory describe themselves as originalists or claim to be enforcing our original law, the laws that stood at the American founding, which stays the same over time until lawfully amended or changed. This isn't limited only to one party's appointees. Justice Jackson, at her confirmation, stated that she looks to the text to determine what it meant to those who drafted it. And Justice Kagan, at her confirmation, said that the founders sometimes laid down very specific rules and sometimes laid down very broad principles. Either way, we apply what they say, what they meant to do. So in that sense, we are all originalists. But on the other hand, outside the courts, originalism faces some very rough waters as part of America's ongoing moral reevaluation of the founding. In the late 20-teens, a colleague asked me in all seriousness, how is originalism supposed to survive, given that we should no longer think of the founders with respect? Rejection of the founding may not be quite so universal, but certainly Americans today are more aware of and understanding of their deep moral failings, particularly and most notoriously in regard to slavery, but also to other original sins of the American Republic, to the widespread dispossession of Native Americans, to gender relations very different from our own, and so on. According to CNN at an event with Justice Sotomayor in 2021, NYU law professor Kenji Yoshino inquired whether originalism will become increasingly untenable as the country's demographic makeup continues to depart substantially from the makeup of the framers. And Justice Sotomayor, for her part, agreed that a number of her colleagues adhere to the philosophy and described as a fascinating question whether and how that will lead to dissonance between what we are deciding and what the general population accepts as what the law should be. If fewer Americans see themselves in the founders, what does that mean for our use of their law? Why should the 200-year-old decisions of a bunch of white male property owners, indeed often slave owners, have binding force for us today? I want to put forward a more modest kind of claim on behalf of the Constitution. We don't rely on the Constitution of 1788 necessarily out of reverence for its individual author's moral authority, though they may well, amid their faults, have done things worth revering. Nor do we use our Constitution because we find ourselves represented in the founding, though many of us who are not the founders' lineal descendants may nonetheless consider ourselves their philosophical heirs. And neither do we use the Constitution out of a belief that it sets out a perfectly democratic system of government, though indeed its system may turn out to be more democratic than many others on offer. Instead, I want to present a small c conservative argument for the Constitution, that we use it because it is, in fact, the Constitution we have, that it's more representative and more democratic than common belief might suggest, and that trying to adopt a new Constitution on the fly, when Americans today disagree quite hotly on what that Constitution ought to contain, is far worse than sticking to the flaws of the one that we have. Noting that our Constitution really is flawed, and that the circumstances of its enactment really were flawed, doesn't tell us what ought to replace it, and how we ought to get there. Indeed, it often assumes away the very disagreement that makes constitutional law necessary. If everyone agreed on what to do, we wouldn't need much constitutional law. Constitutions are there to manage the fact that people disagree, both about substantive matters and about structures of government. They provide a temporary set of issues, even of settlement of issues, even of grave issues, that would cause even graver circumstances if they were allowed to remain unsettled. In other words, we use originalism because originalism is already the law, and because following the law is more important rather than less, the more divided our society might be. So let's start with the question of the authority of the founders. There's a widespread sense that originalism is a form of founder worship, that originalists want to follow the law of 1788 or 1868 or so on, because those periods were pinnacles of human virtue. And if we want to be virtuous, then we should do what Hamilton, Madison, Jefferson, and so on thought. This sentiment can come from either side of the aisle. For example, arguments that the founders' rules are to be reconciled with progressive priorities in a form of liberal originalism, and so on. But what if we find out that the founders were not particularly virtuous, and especially if the Constitution was shaped by that lack of virtue? What then? For example, in a very interesting recent work, Jeffrey Schmidt argues that the Constitution provided for very narrow federal powers, partly out of a fear that the federal government might use its powers to interfere with slavery within the states in which it was practiced. If Congress had been given the power to regulate anything which, in the aggregate, had a substantial effect on interstate commerce, the modern test under which Congress regulates everything from backyard wheat fields to medical marijuana to minimum wages to labor unions and so on, it could surely have regulated slavery, which had an enormous effect on the prices of various goods that were traded across state lines. So, to Schmidt, much contemporary doctrine is therefore incompatible with the original limits on the commerce power. Now, thankfully, slavery is no longer part of the Constitution, indeed is constitutionally prohibited. But Schmidt argues the taint on the rest of the Constitution means, in his view, that the limits on federal power should be ignored. Understanding the constitutional history of slavery, he writes, demonstrates why no one should accept a strong version of originalism today. Congress has to be empowered, in his view, to pass legislation on critical issues requiring a national solution, such as medical care or climate change, because the limits on that power come from a morally flawed source. Now, to my mind, that inference doesn't quite work. From the internal perspective of a legal system, at least, we care about whether a constitutional provision was enacted and not always why it was enacted. Even if congressmen had been bribed to get the 13th Amendment through, it's still part of the law and slavery is still illegal. From there on out, the law stays the same until it's lawfully changed. Even today, lawyers and judges struggle to argue that their rules were, in fact, the rules adopted by the founders, or at worst, that the founders' rules were vague and so their positions fall within an acceptable range. As Judge Bork once put it, how an institution advertises tells you what it thinks its customers demand. Or if those lawyers and judges make arguments based on precedent, the validity of those precedents themselves is understood to turn in part on whether they were correct on the day they were decided, a question that depends not just on other precedents, but on the original rule. In this context, originalism is the publicly accepted means of defending and explaining legal rules. If you go into court and say, yes, Your Honor, the original Commerce Clause is against us, but we had a constitutional amendment in 1937 and it changed everything, you will lose. Likewise, if you go into court and say, yes, Your Honor, that's what the 14th Amendment actually did, but we have a common law constitution, so it's okay now, you will also lose. Lawyers and judges would rather make terrible arguments about what the rule actually was at the founding than say that the founding law was against them and claim support from something else. Not only do these laws stay in place until lawfully changed as a matter of internal legal doctrine, we also have good reason to leave them in place, absent some very substantial degree of consensus on what should replace them. The original Constitution is law today because we use it as law. We look to the past to determine what our law is, because our practice is to take whatever was law as staying law until it's lawfully changed. And we want to be careful about declaring when that old law has been replaced. As my old boss, Judge Williams, once pointed out, at least until we devise time machines, a change in law can have its effects only in the future. Enacting a law today does nothing at all, unless it's applied by people in the future who treat it as part of their legal past. Or as Judge Easterbrook famously put it, old laws are enforced not because their authors want, but because the living want. Decisions of yesterday's legislatures, and the 104th Congress is as dead for this purpose as the 50th or the 10th, are enforced not only because the Constitution does not treat laws as radioactive, but because affirming the force of old laws is essential if sitting legislatures are to enjoy the power to make new ones. Treating the existing laws stable gives current legislatures a very important power, namely the power to leave well enough alone. Just as many people would oppose forcing Congress to reenact all of its laws every 2 years, or to have a new constitutional convention every 2 years, we would not want to deprive ourselves of the ability to leave some parts of the Constitution alone. Of course, some parts of the Constitution are unjust and require revising. But these are present concerns to be decided by present people. They're not judgments about a historical counterfactual, about what the framers would have done if they weren't in the grip of some serious moral defect, such as a desire to protect slavery. For example, the founders might have been entirely right about the importance of protecting state choices, and horribly wrong about which state choices required protection. Saying that a narrow commerce power was about slavery is rather reductive. If slavery hadn't existed, perhaps some other difference among the states might well have led to a similar result. We have a hard enough time figuring out historically what the founders did do, let alone arguing counterfactually what they would have done in circumstances we can hardly imagine. More importantly, it's useless to talk about getting rid of their law because of its moral taint, unless we have an idea of what to put in its place. So for Schmidt, Congress would have power to pass legislation on critical issues. But Americans disagree about which issues are critical and about which require congressional solutions. Absent a very broad consensus, for example, 2/3 of each house and 3/4 of the states, to recall the standard of Article 5, an ad hoc critical issues standard would render the law extraordinarily unstable and any decisions extraordinarily controversial. Just as the counterfactual requires us to assume away the founders' views on slavery, asserting new powers in the modern day on that basis assumes away disagreement about which interests the federal government now should be empowered to advance. Turn now to a second set of concerns, that of representation. Even if we can overlook the founders' moral errors, we still might not feel that the founding generation speaks for us in the relevant way. Had I been at the founding, many Americans can quite correctly argue, I could not have held office or would not have had a vote. So why should the decisions of a small set of people 200 years ago who could vote and who could hold office speak for all Americans today? This critique appeared recently in the joint dissent in Dobbs versus Jackson Women's Health Organization, the case that overturned Roe v. Wade. According to Justices Breyer, Sotomayor, and Kagan, the people did not ratify the 14th Amendment. Men did. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty, or for their capacity to participate as equal members of our nation. And the dissenters went on to say, those responsible for the original Constitution, including the 14th Amendment, did not perceive women as equals and did not recognize women's rights. When the majority says that we must read our foundational charter as viewed at the time of ratification, it consigns women to second-class citizenship. If the idea of originalism is about restoring some past world or past consensus, why should those who were excluded from that consensus feel any need to play along? As Professor Jamal Green has written, a narrative of restoration is deeply alienating. What America has been is hostile to my personhood and denies my membership in its political community. I don't want to understate the force of this critique, which I see as quite serious. Here too, though, the criticism has to be understood as more about modern identity than about past exclusion, more about who is on the outs now and less about who was voiceless then. For consider the question, would I have been part of we the people? Who is the I that would have lived back then? A university professor in a society with very few universities? A Jew in a society with very few Jews? A citizen of Massachusetts, born in New York, who's lived in Missouri, England, Connecticut, Wisconsin, Virginia, North Carolina, almost unimaginable variety of places for the founding era. In trying to construct that counterfactual, we follow the categories that are salient to our modern identities, those that divide us from others today. For example, in many states at the founding, Jews could not hold office, and in some states, Roman Catholics couldn't either. Thus, had I lived back then in my own state of Massachusetts, I couldn't have been a member of the state legislature that voted on whether to ratify the Free Exercise Clause or the Establishment Clause. But few people think about these exclusions today or cite them as a reason why constitutional law ought to be construed as more favorable to Jews and Catholics than might otherwise be the case. And I think the implicit reason is that in modern American society, Jews and Catholics are not particularly on the outs, or at least if they are, it's not typically because of their religion. Today's society is not nearly so stratified along religious lines as was the society at the founding, and so we don't think about religious exclusions as problems that need solutions with regard to original law. By contrast, social distinctions of race and gender are very much with us, and so we see them as dividing us from the founding generation in a very different way. Indeed, even those distinctions that are still with us may not have full expression. So if you look at founding era voting law, the fundamental criterion that did the most work in excluding people from the franchise was that of property ownership. In many states, free African Americans could vote. In some states, women who owned property in their own right could vote. Both of those were rare categories. But property ownership was by far the greatest hurdle. But because class lines are seen as more porous than racial or gender lines, and because the lawyers who tend to ask these questions today would typically pass any property ownership test, that distinction receives somewhat less airtime in the debate. Yet again, the difficulty is less with pointing out flaws in founding era representation, understanding what exactly those flaws mean for us today. Many early feminists opposed the 14th Amendment because Section 2 of the 14th Amendment protected suffrage only for male citizens. Many women, and no doubt many propertyless Americans, opposed the original Constitution, which tended to be favored by commercial interests that were overrepresented among men. Given that both the 14th Amendment and the original Constitution were passed by the skin of their teeth, what should we take from this? Is the more representative alternative a world in which the Constitution lost? Must we therefore return to the Articles of Confederation, which permitted even less federal power and would presumably be even less sympathetic to the concerns of excluded groups today? Or to a Constitution without any 14th Amendment, without an equal protection clause at all? More fundamentally, even if every social group of interest had been perfectly well represented at the founding, there would still be the problem that the founding was 200 years ago. I have no idea where in Eastern Europe my ancestors lived 200 years ago. Most of those villages probably no longer exist. But I'm quite confident that I would disagree with them about many things, and that my worldview is very different from theirs. Had they been included at the founding, I'm not sure that their votes would really speak for me today. The strangeness of that kind of answer shows that we may be asking the wrong question. What really seems to matter in asking whether the people at the founding were like me is whether they shared my views on matters of importance. But as Chris Green notes, asking what would the framers do if they agreed with us about everything is just another way of asking what would we do? And we do not need a constitution to tell us that. After all, as Justice Scalia pointed out, we don't need written constitutions or lifetime appointments or judicial review to protect what substantial majorities now think are fundamental rights. A democratic society, he wrote, does not, by and large, need constitutional guarantees to ensure that its laws will reflect current values. Elections take care of that quite well. The purpose of constitutional guarantees, and in particular those constitutional guarantees of individual rights, is precisely to prevent the law from reflecting certain changes in original values that the society adopting the Constitution thinks fundamentally undesirable. Or more precisely, to require the society to devote to the subject the long and hard consideration required for a constitutional amendment, before those particular values are cast aside. The reason to use a 200-year-old Constitution is the same as the reason to use a 150-year-old statute, or indeed even a 10-year-old statute. That we want some relatively strict criteria for how new things get to be law, and that when a proposal fails to pass those criteria, we stick with what we have. In fact, one might see the representation argument of the Dobbs dissent, which seems so anti-originalist in character, as subtly invoking a fundamentally originalist idea. Suppose that the 14th Amendment had read, "No state shall abridge any liberty that is very important to human freedom." That rule might stay in place over time, as different generations take very different views on what liberties are quite so important to human freedom. In the jargon of modern originalists, we would there have a difference between the original rule that was enacted and the original expected application that the authors thought would come about. In the same way, 2 senators from each state includes Hawaii, even though Hawaii wasn't a state at the founding and no one had even the faintest idea that it might be. But similarly, new freedoms might be recognized under a constitutional provision that generally recognizes freedoms. I think this is, in fact, how the Dobbs dissenters understand the 14th Amendment's due process clause. I think that's the structure of their argument, that at the time, people might not have recognized that reproductive freedoms were as important as they suggest people today do. But to say that is to make a historical argument, an argument vulnerable to historical refutation. The same goes for a famous passage from Obergefell versus Hodges, which found a constitutional right to same-sex marriage. The nature of injustice, Justice Kennedy wrote, is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all its dimensions, and so they entrusted to future generation a charter protecting the right of all persons to enjoy liberty as we learn its meaning. Here, too, what is said to be a highly non-originalist decision is relying at its base on an originalist claim. It's making a claim about history, and it might be wrong about that history. Suppose the generations that ratified the various amendments did presume to know the extent of freedom and didn't write a charter that was quite so open-ended. If so, presumably the case should have come out the other way. But how would we know, except by doing the historical work? Or maybe they only entrusted to future generations a charter protecting particular liberties, liberties they knew about and thought might need protecting, and left any future liberties to future generations to work out through the electoral process, rather than as a matter of constitutionally protected right. Again, how could we tell if not by doing the history? So the argument from representation, as the Dobbs dissenters employ it, in fact rests on an argument about history. We're not bound by everything that the founders thought, in particular because the founders is a group that is smaller than American society as a whole. But we are bound by what they enacted, and that only to the extent that we still wish to follow their Constitution. This, though, brings us to the third objection, that of democracy. Why should we still wish to follow the Constitution if it stops us from doing something we earnestly wish to do? Why should we follow an instrument that misallocates political power in the Senate and the Electoral College, or that doesn't let Congress pass important regulations by majority vote? Why do we have to follow a document that makes it ever possible for a candidate to win a presidential election with 46.1% of the vote when someone else got 48.2% of the vote? If the answer isn't that the founders were virtuous or representative, and if their system isn't all that democratic, why not let us go our own way? Compared to state constitutions or to other instruments around the world, the US Constitution is quite hard to amend. And some provisions, like equal suffrage in the Senate, are nearly impossible to amend. They would require every state to agree, which of course they will not. So why do we have to follow it at all? Once we put the question this way, though, we can see how strange a question it is. Because if Americans today wanted to abandon the Constitution, who exactly is going to stop them? The parchment itself is not going to break the glass case in the National Archives, climb out, and start shaking you until you comply. To say that the Constitution won't let us is just to say that actual people, other Americans, who are committed to following the Constitution, who may even have promised to follow the Constitution as a condition of taking office, aren't willing to go along with what they understand to be a violation of that Constitution, especially one that lacks the kind of broad-based support with which you could just amend the Constitution and keep everything above board. And part of the problem here is that no more democratic alternative is clearly on offer. Many Americans today, perhaps even a majority of those in this room, might be uncomfortable with replacing our constitutional amendment process with something like the California initiative process. Even we don't want everything in the Constitution to be up to a vote of 50% plus one. If we could agree on a better way of changing the Constitution, we could vote for it. Maybe even we could pass it by means of amendment. But for the moment, so long as we can't actually agree on a better system of constitutional change, we keep going with the one that we have. Moreover, to the extent that the Constitution is undemocratic, that's primarily so because it takes an unusual view of the demos. The Constitution doesn't treat America as a single, undifferentiated democracy, but as a collection or mixture of a whole bunch of little democracies, each of which combine to form the United States. If the point of the Constitution is to enable Americans to achieve self-government at both the state and the federal levels, that might require circumstances in which a national majority loses. On the question of what policy to have in Ohio, all 49 states might vote one way, and a majority in Ohio might vote the other way, and the majority in Ohio wins. Or if we turn our presidential elections over to a temporary mini-Congress, which we call the Electoral College, and which is elected by the various states in the same way that Congress is, we might sometimes find that 46.1 beats 48. The better comparison here would be with something like the European Union, where some decisions require unanimity across member states, while others might be made by cross-cutting majorities. Of course, US states are not as independent as member nations of the EU, but both rely on the idea that a mixed government might still be legitimate even if it is not fully democratic, because it's trying to preserve democracy at different levels at the same time. So it might have made sense for the founders, who had to persuade some pretty independent states to sign up for the new government, to depart from strictly majoritarian principles, and to assure those states that there wouldn't be a bait and switch, that the new rules wouldn't be changed by a vote of 50% plus one. Virtually every corporation in the country requires some kind of supermajority support for fundamental changes, like amendments to the Articles of Confederation. And so it wouldn't be very strange at all that the US Constitution might do the same. Indeed, by comparison, Article 5's supermajority requirements are comparatively light. They really require only majorities which are very broadly distributed. If 51% of Americans in every state and every congressional district across the country wanted a constitutional amendment badly enough to call their senator about it, it might well get a unanimous vote in both houses of the Congress and in the state legislatures. Obviously, most measures don't have uniformly distributed support like that. Interests vary from place to place. But precisely because part of the point is to preserve self-government at the state level as well as at the federal level, it might make sense for us today to expect some kind of broad-based support like that before making absolutely everything in the Constitution up for grabs. Again, I'm not claiming that Article 5 is the best possible amendment mechanism or that all is for the best in this best of all possible constitutions. My argument is just that our existing Constitution is not so anti-democratic that it loses all claim to our adherence, especially when no other alternative has adequately broad support. So if you leave here with any memory whatsoever of my talk today, I hope you leave with 2 points in mind: that you can't beat something with nothing, and that you have to be able to get there from here. The arguments for discounting the founding and for discounting the original law that the founding gave us have to be comparative. They have to identify what new law we would use in its place, including what new law we'd use on the topic of constitutional change. Switching to what seems like a better system on paper may, in fact, only make things worse. After all, the arguments against using 200-year-old law are easy to frame on paper. As Louis Michael Seidman has put it, instead of arguing about what is to be done, we argue about what James Madison might have wanted 225 years ago. Instead, Seidman argues, we should rely on a network of customs, rules, precedents, and legislative texts, which can be discarded when advocates persuade people that they are unjust, ineffective, or outmoded. It's true that originalism can unsettle long-settled doctrines like these. But the reason it does so is precisely that we have no settled doctrine of constitutional desuetude, no expiration date for the First Amendment or for the Commerce Clause, nothing that lets court decisions stand in for decisions by Congress or by the state legislatures. Between Roe, Bowers, Citizens United, or Plessy, there's simply no stable constitutional settlement that can offer consistent answers on whether to retain or discard past cases or lines of doctrine, other than whether those cases correctly reflect the Constitution that they purport to interpret. Our network of rules as Seidman describes it, includes a rule in which the original Constitution stays law until it's amended. And there's no evading that fundamental tension in any attempt to replace that original Constitution with common law custom instead. Moreover, allowing those rules to change whenever advocates persuade people to change them presumes that the right people will always be in the right seat to decide. Many legal academics may have come of age during the heady days of the Warren Court, when it was possible to think that the Supreme Court was theirs by right and that the onward march of progress would never be impeded. If recent events have shown anything, it's that there are no permanent victories in constitutional politics. The other side will be in charge at least half the time. The fundamental problem is that people disagree on what is to be done. And that is why we keep looking back at James Madison, not because he'll tell us what's to be done, but for an accepted means of channeling those disagreements today. For example, although I do not share these disagreements, many people disagreed about the validity of the 2020 election. And to my mind, it is a very good thing that we had established rules, both in the 12th Amendment and in the Electoral Count Act, passed under the Necessary and Proper Clause, to lay out the authority of the Vice President when presiding over the counting of the votes. If that authority was instead supposed to be determined by arguing about what is to be done, as Seidman suggests, rather than according to pre-existing standards on which people could agree in advance, the events of January 6th might have turned out very differently, and to my mind, not for the better. Or consider the argument of Samuel Moyn and my colleague Brian Dorfler that we should adopt a system of congressional supremacy, doing politics through ordinary statute, rather than fighting over the heavy weaponry of constitutional law from the past. If legislatures just passed rules and protected values majorities believe in, they argue, the distinction between higher law and everyday politics effectively disappears, and we could have the present electorate decide on fundamental values like racial equality or environmental justice. Here, too, the problem is not so much substance. There are plenty of countries with parliamentary sovereignty, and they seem to do just fine. The problem is that people disagree on whether to impose parliamentary sovereignty here, and trying to impose it by fiat could create more problems than it solves. In a country like the United Kingdom, with centuries-old traditions of judicial independence and the rule of law, leaving everything up to a central legislature under soft constitutional norms might work. Though, of course, the continuing debates over devolution in Scotland suggest that federalism is a problem for them, too. But in the United States, where people also hotly disagree over fundamental values like racial equality or environmental justice, it's hard to imagine that transition working very well. If the basic structure of government, like whether to elect the president by majority vote or to limit judges to fixed terms, as they write, is suddenly up in the air, then the kind of partisan gerrymandering we've seen thus far might pale in comparison to the kinds of power grabs that political factions might attempt and might feel they have to attempt, for fear of being subject to similar power grabs by the other side if they don't. A world in which none of your long-standing rights seem secure from hostile majorities, in which absolutely everything is up to who controls the next Congress, is not a world in which our traditions of democratic agreement would work well. Indeed, for those who see our constitutional decision-making as fundamentally motivated by politics, the 2020 election cases are almost inexplicable on political grounds. Why on earth should election officials from one party certify elections in which the other party wins? Why on earth should judges appointed by one party care about abstract questions like subject matter jurisdiction or standards of appellate review, when failing to intervene would only hand power to the other side? One can try to tell some extremely complex story in which they're playing a very long game, some conspiracy theory in which they're preparing for a political victory to come. Or one could say more plausibly that our system relies on officials being willing to commit to shared rules, which stay on the books until they're lawfully altered. That kind of commitment is a two-way street, and we abandon it only at our peril. I want to close with a few more words from my old boss, Judge Williams, who unfortunately we lost to COVID in the summer of 2020. In discussing what he called the remarkable persistence of Magna Carta, he wrote, "Rhetoric has force by focusing the mind. The example of success in Magna Carta emboldens others. I want to mention two advantages that Magna Carta possesses now but did not at its outset: its very antiquity and the force of habit. The two are closely related but not identical. Even in a country that exalts novelty as much as America, it is clearly a rhetorical advantage to be able to start a sentence, 'For 800 years we have respected.' This, of course, leaves uncertain who we are and the possible irregularity of our respect for the document and its times. But you don't have to be a Burkean to accept, at least provisionally, The idea that something that has worked for 800 years probably has something going for it. As to habit, one doesn't have to get into theories of addiction to realize that if generations of people in a society have heard teachers and parents refer to a document and its ideas with awe and admiration, the practice of doing so is likely to continue. In a way, the forces of both antiquity and habit manifest the idea that nothing succeeds like success. That idea is a truth, but obviously a dangerous one. Many practices that we now rightly see as heinous have much longer pedigrees than Magna Carta, most obviously slavery. But an idea's rhetorical advantages are real, and those who find an idea supported by reason and experience would be fools not to employ rhetoric where it is helpful. Judge Williams therefore concluded that systematically slighting the origins and meaning of the Constitution and its precursors would be cause for alarm. Not because those origins are immune from criticism, far from it, but because that which is valuable in them, a system of self-government, of individual rights, of aspirations toward equal justice under law, is very easily lost. A commitment to the original Constitution is not a commitment to flawed people from 200 years ago. It's not a commitment to downplaying or hushing up the very real injustices that shaped the past. Rather, it's a commitment that Americans today make to each other to seek particularly broad-based support before attempting to revise their fundamental law. It's a commitment that prevents us from wishing away disagreement, from assuming that concerns shared by one or the other half of the country can be somehow discounted or ruled out of bounds. That commitment, like all commitments, can sometimes make it harder for us to do things of value, to advance other vital goals, to correct some other grave wrong. But today, with the divisions among Americans more vivid, and the stability of the Republic more commonly questioned than ever I can recall in my adult life, it can still be a commitment worth making. Thank you.
Mr. Senator, any questions for about 15 minutes?
I'd be happy to. Yes?
I agree with you that the question of what might the founders have done about this is not a very useful one. But I'm curious about what you think from a textualist, originalist perspective, what law can do to acknowledge the fact that the world does change and that just because a concern is new doesn't mean that it is less legitimate.
Absolutely. I think that the founders were very much aware that the world changes. And they saw this, though, as a drafting problem and not an interpretive problem. So there were often debates about how much should we hard code in the Constitution and how much should we leave open. So you can imagine, should they state the tax rates in the Constitution? And the answer is no, because we're just going to need different tax rates over time, and there's no good way to entrench that against the future. But those sorts of choices are choices that they can make and that they might make well or poorly. Any legal regime can do that. Some legal regimes say that the tax brackets are going to be adjusted with inflation, and others say that the levels of taxation can only be adjusted by statute, and Congress has to get involved every time we're going to change them. So the question of how much change to leave open and who should be the person who decides when it is changed enough to matter are questions that any person designing any system of law has to deal with. So I'm not saying that the framers, produced a perfect set of rules on that. It's just that any set of rules is itself part of the legal system. Any legal system will have views on which changes matter for what. And there is no general provision that a set of laws can make against potentially needing to be revised. Yes?
Yeah, it just seems to me that, thank you. Sometimes strict adherence to the Constitution actually puts us in danger. And, I'm thinking specifically of the Second Amendment. And, I just don't think the framers had any idea of the powerful weapons that would be available to any 18-year-old and on any day of the week. And I know that other countries that don't have the Second Amendment in their constitutions have been able to pass meaningful gun control legislation. And so I just was wondering if you could maybe speak to that.
Sure thing. I mean, I would note two things. The first is that I agree. I'm sure that modern weapons would have been quite surprising to the founders. But I don't know exactly what rule would, it's hard to play out the counterfactual there. And it's also hard to play out the counterfactual of what rule should we adopt that would actually get broad-based support? I mean, in virtually every state, there are state-level rights to bear arms. Many, many states have much more extensive gun rights than the Second Amendment has ever been construed to require. And so part of the problem there is not the Constitution per se, but rather the fact that people today don't agree on what kind of gun rights the states should allow, and the fact that there's very little trust on whether a legislature can responsibly exercise those powers. If that were not the case, if people trusted the legislature to do it wisely and well, perhaps we would see more willingness to pass an amendment that enabled them to do so. I don't see that as a reasonable possibility, in part because people just would get too skittish at any conceivable language one would write to describe the power of a state legislature to regulate guns. The second point that I want to make, though, is that this is an argument which one sees all the time in constitutional decision-making. So the argument in the steel seizure cases was, look, we have there's going to be a steel strike. This is during, conflict. It's going to be a national security problem. The government just has to have the ability to seize the steel mills. And none of the sort of provisions that set out executive authority sort of could envision the situation that we're in now. And that will always be the case, because by definition, they were always written before today's situation comes to be. But we also recognize that there are situations where we don't want to say, okay, then everything's up for grabs, and that whoever's currently in power can make whatever decision they think they need to make, given the new circumstances that face them. And again, this is a drafting problem. This is a problem of figuring out what rule do we want to lay down to say, okay, here are the circumstances in which you can depart from the rule we previously had. And that becomes very, very difficult. The difficulty of doing that is really the problem, much less so than the existence of a 200-year-old Constitution.
Hello. I had a broader question about constitutional legitimacy and change. Who has the authority to potentially enact a new constitutional convention? How does that authority derive? And how do you know that authority comes from whatever source you cite?
I mean, in our system, so two things. One, there is a provision in Article 5 for new constitutional conventions whereby states can ask Congress to call it. And there's an ongoing debate about whether they have in fact done so. Michael Stokes-Paulson, in his general theory of Article 5, goes back through the history of some of the state calls for this. But the one thing I want to note is that would be a constitutional convention for proposing amendments under the existing system. If the question is who has authority to sort of wipe the slate clean and do something totally new, well, the answer is nobody does. But it's not like the revolutionaries had authority to fight against the British either. To that extent, the only thing that succeeds is success. So you could have a system whereby we just all got up tomorrow morning, we're like, you know what, we hate this Constitution, let's do something else. And the Constitution, again, the parchment's not going to stop you. The only difficulty, of course, is that if we don't know what the something else is, if it's more a desire for something new than an actual agreement on particular provisions, then it's not very likely that you'll actually be able to achieve the kind of social consensus that any sort of change like that really requires.
Thank you. I'm very interested in this comparison between something like the British system and less codified form of government versus our written system. And I'm just curious if the first generations of Americans who had written constitutions, various colonies and states, were they aware of or thoughtful of the fact that they were doing something different than the British system, strictly speaking? And if so, how that could be incorporated into a conversation about which of those systems work different ways?
So I think that this is historically debated. Some of the earliest state constitutions were not seen as fundamentally different entities. They were sort of seen as entries into a broader customary system rather than enactments in the tradition of statutes. On the other hand, by the time you get closer to the Constitution, it seems pretty clear that folks are debating the language as if it is to be an enactment. Like if you look in the Federalist, when people are arguing, how will this Constitution be read? The answer that Hamilton and others give is, well, it's just going to be like a big statute. You know, we'll use all our standard tools for interpreting statutory language. When you look at the Ferran debates at Philadelphia and the ratification conventions about, you know, what will this particular phrase do? It sort of seems less like this is something like the English Bill of Rights. It's less like or Magna Carta, let's say. It's less like a sort of general body of principles and more like specific requirements. I mean, one thing I should say, of course, is it's not at all clear that you know, Magna Carta, for instance, was capital M, capital C, Magna Carta when it got adopted. It's full of stuff like, you know, no one owes interest on loans to the Jews, and we should take down all the fish weirs, and the heirs of Gerald Dethay shall never hold office in England, because seriously, forget that guy. You know, it's full of tiny little statutory provisions that are not at all what we think of when we think of the principles of Magna Carta today. But it seems to me like the Constitution, which has all sorts of very specific rules about, you know, attainders of treason, working corruption of blood, and exactly who's supposed to open which envelopes with regard to, you know, electoral votes, is much more along the lines of a written enactment than a sort of codification of common law custom. I'm sorry, ma'am, did you have a question as well?
Thank you, Professor. Maybe a follow-up to the Second Amendment question. When do you know, what clues do you look for in determining whether it's a drafting problem or an interpretation problem?
So, you know, the piece that I'm thinking about in that regard, Caleb Nelson's article on originalism and interpretive conventions, looks at the discussions at the time of the founding and says, look, did people advert to this issue? When, you know, did they talk about the problem that circumstances might be different in the future? And his answer is yes. But where they talked about that problem seemed to be in the way that, you know, people in Congress today would think about that problem. They'd say, okay, are we hard coding too much? Do we need to leave more open? If we're going to leave more open, who should be the person deciding it? To whom do we allocate the authority to make the call that things are different now? And his point is just to say it's not that one could never have that as an interpretive problem, but just to say that it's not a surprise to those who were drafting these instruments that they might have to worry about changes in the future. That was certainly something that people talked about then, just as we talk about it now. And so it's not as if we could say, those benighted framers, they had no idea that things changed, and therefore we can sort of read what they produced very differently because these concerns were just completely off their radar screen. In fact, they were very much on their radar screen.
So my question is just, practically speaking, what would the type of widespread change or support needed to make a meaningful change look like? What would average citizens need to do? How would our Congress be involved? Our election system? Just what would it look like practically?
I think practically it would look like pushes for constitutional amendments or for statutes that would have the effect of making changes in electoral practices. So Congress has a lot of control over the time, place, and manner of federal elections, and states have a lot of control over which amendments they ratify and even, you know, can propose. So if you had, you know, 40 state legislatures saying, we would love an amendment of the following type, that's a good way of getting it onto the national political scene and signaling that ratification would be possible. Now, obviously, that's hard. I mean, there's a reason why people say, gosh, you know, it's hard to find anything that 40 states will agree on that would actually make a meaningful difference. But ultimately, that's just a reflection of the fact that people in lots of different places disagree. One other avenue for change that has not been adequately explored, in my view, is things like interstate compacts. You know, if states want to get together and say, we'd really like to have a different healthcare regime that's at higher than the state level, you know, they can do that and ask Congress's consent. even if not everybody else has to play along. I mean, there are lots of different avenues for change in the system. Obviously, not all of them are particularly easy, but the sort of difficulty or easiness is a reflection of the degree of disagreement rather than some sort of external thing that someone else is doing to us.
Thank you.
Mr. Sachs, you had described a phenomenon where people are bringing arguments to the Supreme Court, and they're using very creative interpretations of original law. So the 14th Amendment, maybe in Dobbs or in Obergefell, for example. And I wanted to see if you thought, was there also an additional connotation to your comments that, not that the arguments were in bad faith, but what pushes them to make, or do they recognize that the arguments they're making are weak, I think as you described, under maybe looking at the original law at the time period, but maybe would be powerful living constitutionalist arguments if rephrased in that format, but were not rephrased in that form. So do you have a view about whether the actors themselves recognize that phenomenon?
Yeah, so I think it's not bad faith, really. I think it's much more motivated reasoning and sort of just a familiarity with a certain kind of rhetoric and form of expression. So it is entirely possible to write a brief that says, look, the framers were benighted, and our society now recognizes liberties that they couldn't possibly have imagined. But those arguments just don't make it onto the page, in part because they just sound wrong to most lawyers. There's something that, and that's contingent. You could imagine a society in which they didn't sound wrong, in which everyone was happy to argue in those terms, and maybe at various times in our history, people have been happy to argue in those terms. But even during the Warren Court, for example, citations to the Federalists are at their peak. They're not necessarily good citations. I mean, they might be sort of, very sort of, arguments that sort of gesture at original law more than really dig into the details. But there's certainly a sense in which the argument is expected to be responsible to the history in some way, even in the form of the framers entrusted us with the Charter of Liberties and so on. Like that has the form, if not the substance, of a historical argument. And there's a reason for that, in my view.
Other questions for Professor Sachs? Please join me in thanking him.